Hi, everyone. My name is Rozanne Andersen. I'm the Chief Compliance Officer for Ontario Systems. I just returned from the Receivables Management International Association's annual meeting in Las Vegas last week. Yes, it was a live meeting. It was well attended. They indicated that 500 people registered on site. And they did not miss a beat in terms of implementing all the appropriate safety procedures for their attendees. The kickoff session was led by a gentleman named Pahl. He is the former director of the Consumer Financial Protection Bureau. And he was invited to share his predictions about what is in store for the debt collection industry under the new Biden administration's CFPB. And his presentation, I personally thought was fascinating. He explained that the first order of business for the Consumer Financial Protection Bureau is to actually have a director seated. Now, President Biden has selected a fellow named Rohit Chopra, formerly the director of the Federal Trade Commission, as the person to lead the CFPB under his administration. But in order for that to happen, the full Senate must agree, or basically by vote agree to seat Mr. Chopra as the CFPB's director. In March, the Senate Banking Committee ended up in a bit of a logjam when Mr. Chopra was nominated and voted upon by the Senate committee, the Senate Banking Committee. They ended up with a 12-12 vote, a tie vote. 12 Democrats voted to seat him, 12 Republicans opposed his nomination. And that basically created a stall. Now, what Tom Pahl explained is that what is likely to happen is that Senator Schumer from New York has the ability to introduce by motion to the full Senate the nomination of Mr. Chopra as the director of the CFPB. And as of this date, April 20th, 2021, that has not taken place. However, when it does take place, the nomination of Rohit Chopra will be presented to the full Senate. And if there is a tie in the Senate, for whatever reason, Vice President Kamala Harris will be able to break that tie vote, in which case the directorship will be seated and basically filled with Rohit Chopra as the director. So that's what's going to happen, or a prediction as to what will happen in terms of the directorship. Now, the question is, what impact will he have on the industry as the director of the CFPB? And the answer is he's going to have a huge impact on the industry. This is because he is an aggressive what would you say, protector of the consumer. He is he believes that the unfair, deceptive, or abusive acts and practices section of Dodd-Frank should be used at every corner. It should be that the CFPB should aggressively pursue actions not only against the good actors, but also the bad actors. He is a fan of regulation by enforcement. What that means is, even though the law may not be clear, even though the regulations may not be clear, if there is reason to bring an enforcement action against a particular company because their consumer harm is perceived to have taken place or will take place, he believes that an enforcement action should be pursued. So we really are going to be leaving the, I guess I'd call it the hiatus that we've enjoyed as an industry under Director Kraninger, and we are now going back to the type of era we experienced under Director Cordray, but only on steroids. Chopra is going to definitely make the Cordray administration or directorship pale in comparison to what he expects out of the CFPB, both from a supervisory standpoint as well as from the enforcement standpoint. Now, with regard to the rules, everyone is kind of waiting with bated breath. Will these rules be rescinded? What does this 60-day extension mean that we've recently heard about? And Tom Pahl set the record straight in the following manner. He said, as we know, the CFPB, likely in response to the administration's request to give Chopra a chance to be seated and to take over the CFPB. For that reason, he believes the staff of the CFPB, on its own volition, announced that it would entertain a proposed rule to extend the implementation date of the Regulation F from November 30th of 2021 to January 29th of 2022. Basically a 60-day extension for the reasons I explained. Tom Pahl thinks that that's highly likely to take place. It was not driven by a group. It was not even necessarily driven directly by a consumer group. He really underscored the fact that it was probably at the direction of the administration to give the system a chance to basically have Chopra seated and give him a chance to make his mark on the CFPB. Now, the question is, will Chopra try to take steps, as we have seen it with some other regulations, to try to rescind or revoke or unravel the final Reg F as we know it today? And Tom Pahl suggested that's highly unlikely, that the industry, if he were a betting man, my words would be, he would say it is highly unlikely that the new rules as presented will be rescinded. What he thinks will be likely, however, is that under Director Chopra, that new rules will once again be proposed for the debt collection industry. New rules that expand things like call restrictions, expand the rules around emailing and texting consumers, expand the definition of UDAP as it applies to consumer debt collection practices. He thinks that is highly likely that new rules will be proposed. Now, that does not happen overnight. And he does not think they will be easily just added on as a little addendum to Regulation F as it stands today. He explained that it is proper for those kinds of new rules to go through a notice and comment period, just like our Regulation F had for what? Well, it was worked on for 7 years, probably notice and comment for 4 years, roughly. So these things do not move quickly under normal circumstances. Now, keep this in mind. During the Trump administration, regulation as a whole was frowned upon. So my personal opinion is that the reason we did not see the final Regulation F move more quickly during the 4 years where Donald Trump was president is because, as a general rule, the administration was opposed to regulation in the first place. Again, my opinion, I think now under an administration that is pro-regulation across the board, that it is possible that some of these notice and comment periods may be shortened and that things will move through the regulatory process with much greater speed than we are accustomed to or we have seen before. Tom Pahl also issued a warning for larger market participants, not only the existing ones who should be ever ready now to prove and provide evidence of compliance with Regulation F when called upon by the CFPB, but also in the sense that agencies that otherwise thought they were insulated from the direct supervision of the CFPB. What I mean by that is they did not expect to be examined, where the CFPB calls and sets up a time where they actually bring 11, 12, 15 lawyers on site for several months in some cases to examine the agency's compliance management system. Anyway, what he predicts is that the threshold will be lowered as that relates to the definition of the larger market participant. I think we all know, but I'll remind everyone, the current definition of larger market participant for the collection industry, for the third-party debt collection industry, is that the agency, law firm, debt buyer, whomever, whichever organization or entity is subject to the FDCPA, that if that entity generates more than $10 million in fee revenue, collection fee revenue per year, excluding revenue resulting from the collection of medical debt, that organization qualifies as a larger market participant. And that means that as an LMP, the CFPB must directly examine them, just as banks are regulated, and just as banks are examined, so too are these larger market participants. So what Tom is saying, if the threshold is changed, so it drops down to 5 million, 8 million, some other million, that means that agencies that are now smaller in certainly in terms of fee revenue, will fall under the direct supervision of the CFPB. And that means they are going to pay a high cost for compliance, not only with the new rules, but with building a robust compliance management system, to the extent they have not to date done so. The other thing he explained is that the larger market participant definition that now, as I explained, excludes collection fee revenue from medical debt. He believes that the party's over in that realm, and that medical debt collection will fall within the definition of larger market participant, and that the fee revenue from the collection of medical debt will be considered when determining whether an agency, collection law firm, or debt buyer meets that minimum threshold in fee revenue to satisfy the definition of larger market participant. So I would expect we're going to see a lot of hiring going on at the CFPB level. I would expect the regional offices to increase in size. I would expect that more and more agencies will be receiving calls and having from the CFPB, notifying them that they will be examined by the CFPB, and then it's just a matter of scheduling that examination. So that's a big wake-up call, and it should be of great concern to agencies, collection law firms, or debt buyers who have to date escaped or been able to avoid a CFPB on-site examination. He also explained that as a whole, the industry should expect aggressive enforcement industry-wide. He explained that under the Federal Trade Commission, their strategy is to go after bad actors, to kind of clean up various industries that they regulate under the Federal Trade Commission regulates. He said the CFPB is going to be a little bit different. He said they are going to go after, as I said, the good actors and the bad actors. They are going to, under Chopra's directorship, Tom Pahl expects these examiners, when in doubt, transfer the file to enforcement. Get those enforcement lawyers all over this issue and see if there's existing consumer harm, past consumer harm, or potential consumer harm resulting from any of the acts or omissions of the organization. So that's scary as well. For under the Trump administration, I think as an industry, we enjoyed the refreshing approach, I'll say it that way, whereby the industry really kind of stopped with the guidance documents. It was no longer, they were no longer making these stump speeches declaring, you better read those guidance documents because they have the force and effect of law, in our opinion, or read all of these enforcement action summaries and read all the consent orders that we publish because, beware, we will consider the results of our enforcement actions to be the equivalent of the force and effect of law when we conduct our examination. So basically, it was, out with the Administrative Procedures Act and in with regulation through enforcement, regulation through guidance documents. The reason that's problematic in an administration, regardless of your party line that you follow, is that we have something called the Administrative Procedures Act, and the idea of that act is to have agencies that are considered administrative bodies follow that act, whereby they propose rules, allow stakeholders to comment, then they take it under consideration, then they may even issue another round of rules, maybe modified rules, but ultimately they get to the point where they issue final rules based on stakeholder comments, research, market research, statistical research, focus group research, you name it. When you abandon that kind of a process, it becomes a little bit more scary for members of an industry, such as the third-party debt collection industry. As a couple of parting thoughts, he explained that service providers should beware as well. He expects that under the Chopra administration and directorship, that those who provide a material service to third-party debt collectors will also be subject to examination as a covered entity, if you will, and that service providers will be facing much greater scrutiny in terms of their compliance management systems. Chopra himself has a bias that technology companies in particular can influence whether a body of consumers will be harmed or not harmed, just based on the technology alone. So I am personally very wary of what steps may be taken with regard to the service provider population. And if you are an agency that a debt buyer or a collection law firm or a service provider, all of us are heads down updating compliance management systems, not only to comply with the law as written today, but to comply with Regulation F as it is as it goes into effect in less than a year at this point. Thank you for listening to this video podcast today. I hope you found it helpful and valuable, and I look forward to visiting with you another time. Thank you.